You are in trouble. Not the abstract kind, the kind that has a court date attached to it. Maybe it's a landlord dispute. Maybe it's a car accident that wasn't your fault, but is being treated like it was. Maybe it's something smaller, a contract you signed without reading, a debt collector who has crossed a line, an employer who let you go in a way that didn't feel legal but you can't prove it. You need a lawyer. What happens next has almost nothing to do with the law. It has everything to do with your balance sheet. Level 1. You cannot afford a lawyer. You search online. You find a number for a legal aid clinic. You call it on a Tuesday afternoon and are placed on hold for 11 minutes before someone picks up. The person who picks up explains that the clinic serves clients below a certain income threshold and asks you a series of intake questions. You qualify. An appointment is scheduled for 3 weeks from now. You show up. The waiting room has plastic chairs and a television mounted high on the wall, playing a news channel no one is watching. You wait 40 minutes past your appointment time. When your name is called, you are brought to a small office where a law student supervised by an attorney will handle your case. They are not incompetent. They are overwhelmed. The caseload per attorney at most legal aid organizations runs between 300 and 500 active cases. Your file is one of them. The law student assigned to you is earnest and prepared and has read your intake form carefully, but they have 17 other files open on their laptop, and the supervised attorney who reviews their work has a docket that would be unreasonable for 2 people, let alone 1. You explain your situation. They take notes. They explain your options in language that is technically accurate and practically difficult to follow because it assumes a familiarity with legal process you do not have and does not pause long enough to check whether you are keeping up. If your case is simple, you get help. If your case is complicated, you are told that the clinic cannot take it on, and you are given a list of other organizations to contact. You call those organizations. Some have closed intake, some serve a different county, one has a 6-month waiting list. The legal system was designed with representation as its foundation. At this level, you have representation in name. What you have in practice is a system straining under its own weight, trying to give you something real with almost nothing to give it with. You are not a client here. You are a case number in a spreadsheet that is already too long. Level 2. You can afford something small. You find a solo practitioner through an internet search. His office is above a tax preparation service in a strip mall. The consultation is free for the first 30 minutes. You arrive 5 minutes early and wait in a room with 2 chairs and a dying plant. He is pleasant. He listens. He quotes you $1,500 for a straightforward matter and explains that anything beyond the scope of that retainer will be billed at $175 an hour. You write the check because you don't have a better option and because the problem is real and getting worse. What you get for $1,500 is competent. He knows the law. He files the paperwork correctly. He responds to your emails within 2 or 3 days, sometimes longer if he is in court. When you call, you usually reach his voicemail, and he calls back the same day or the next morning. He does not have a paralegal team. He does not have a junior associate doing research while he strategizes. He is one person managing every client he has taken on, and the economics of a solo practice mean he has taken on more than is comfortable because the alternative is not paying his own bills. The work gets done. But you are aware, throughout the process, that you are navigating a system that was not designed to be navigated this way. Every form has language that assumes you understand what the form is for. Every deadline assumes you know it exists. Every step that seems procedural carries consequences that are not explained until after something goes wrong. When the matter resolves, you feel relief, not satisfaction. Relief that it is over. Level 3. You have a real retainer. You are a small business owner. A contract dispute has turned serious. A former partner is claiming ownership of intellectual property you built before the partnership existed. This is not a strip mall problem. You find a mid-size firm, 8 attorneys, 2 paralegals, a front desk that answers on the first ring. The partner you meet with charges $380 an hour. The associate who will handle the day-to-day charges $240. The paralegal who manages documentation charges $95. You are told up front how the billing works, which is the first time in your life a lawyer has explained that to you without being asked. The difference is immediate and structural. When you email the associate, the response arrives the same day. When you have a question about strategy, You are given a 30-minute call where someone has already reviewed your file before picking up the phone. When a deadline approaches, you receive a reminder rather than a surprise. They have seen this kind of dispute before. They have a template for it, not because they are lazy, but because pattern recognition in litigation is what experience produces. The arguments are organized, the documents are indexed, the opposing counsel is known to them, which matters more than it should, but matters enormously in practice. You pay $22,000 before this is resolved. The number is painful. But the outcome is good, and more than that, the process felt managed. You were not alone inside it. Someone who understood the terrain was walking it with you. That is a different experience from everything that came before it. Not just better service, a different category of what legal representation actually means. Level 4. The firm knows your name before you call. Your net worth is somewhere north of $2 million. You have a business, a property portfolio, and an estate plan that was written 3 years ago and probably needs updating. You are not in crisis. You are managing. You have a relationship with a firm, not a transaction, a relationship. There is a partner who handles your corporate work, another who manages your real estate transactions, and an estate attorney who drafted your trust documents and emails you once a year to ask if anything has changed. When something does change, a new acquisition, a partnership restructuring, a lease negotiation on a commercial property, you make one call. The partner coordinates the rest. You are not explaining your history every time you need something. They already know it. Your files are maintained, updated, and accessible to the team that handles your work. The billing is still hourly, but the relationship changes the math. Because they know your situation, they don't spend time getting up to speed. The efficiency of a known client relationship compresses hours. A problem that would take a new attorney 12 hours to understand takes this team 3 because they already have the context. You also get the call you didn't ask for. When a relevant case decision comes down that affects your industry, someone sends you a note. When a regulatory change touches something in your estate plan, the estate attorney flags it before you've heard about it anywhere else. The firm is not waiting for you to identify problems, they are watching for them. This is what a legal relationship looks like when it is functioning the way it was designed to. Proactive, coordinated, and built around continuity rather than transactions. Level 5. You have outside counsel on retainer. Your company generates $40 million a year in revenue. You have 60 employees. You operate across 3 states. The legal surface area of your business is large enough that you have an outside counsel arrangement with a regional firm, a flat monthly fee that covers ongoing advisory work and reduces the hourly rate on everything else. You also have a part-time general counsel, not a firm, a person. Someone who sits inside the business 2 days a week, attends leadership meetings, reviews contracts before they are signed, and identifies legal risk before it becomes legal expense. The economics of this arrangement are counterintuitive until you see them clearly. The general counsel costs you $180,000 a year, but the contracts she catches before they become disputes, the employment issues she resolves before they become litigation, and the regulatory filings she ensures are correct before an audit, those are not line items. They are costs that never appear because she prevented them. At this level, the law is not something that happens to you. It is something you manage, the way you manage operations or finance. Legal risk is a category on a dashboard. Your counsel is part of the team that watches it. When you do engage outside counsel for something significant, an acquisition, a major dispute, a regulatory matter, the outside firm already has a relationship with your general counsel. The handoff is clean. The context is already there. The process feels less like seeking help and more like deploying a resource you have already prepared. Your net worth is above $20 million. When a significant legal matter arises, you are not calling a firm is calling you. You have a relationship with one of the top 50 firms in the country, and that relationship is managed at the partner level by someone whose client list is short and whose attention is nearly undivided. When you have a matter, a team is assembled. Not assigned from a general pool, assembled, specifically for your situation, pulling in the attorneys whose expertise matches what your problem requires. A tax partner, a litigation specialist, a regulatory attorney. They have a kickoff call before they speak to you. By the time they present your options, they have already done preliminary research, identified the likely arguments on both sides, and formed a view on strategy. You are consulted on strategy, not educated on process. The process is their problem. Your role is to make decisions. The billing is significant. A complex matter at this level can run $500,000 or more. But the bills are reviewed by your CFO and your general counsel before they reach you, and by the time they do, they have been audited for reasonableness. You are not reviewing line items. You are approving a number that someone whose job it is to watch those numbers has already examined. What you receive in return is access that cannot be purchased as a single transaction. It is built into a relationship that the firm values because you are a named client whose business represents meaningful revenue, whose referrals matter, and whose long-term trajectory makes you worth investing in now. The law works for you at this level in the most literal sense, not because justice is purchased, because the people who understand the system most completely are entirely focused on your outcome. Level 7. The lawyers come to you. Above $100 million, the dynamic inverts completely. You do not hire lawyers, you retain them. The distinction is not semantic. Retaining means the relationship exists before the problem. It means a partner at a firm with 800 attorneys knows your name, knows your holdings, knows your family structure, and is thinking about your legal exposure on a Tuesday afternoon when you haven't called anyone and have no immediate need. When something arises, and at this level of wealth something is always arising, your legal team is not assembled, it is activated. They were already there, already briefed on your situation, already in communication with your family office and your financial advisors. The legal work does not begin when you call, it has already begun. The firms competing for relationships at this level do not advertise. They are introduced through networks, through other advisors, through the quiet circulation of names among people who move capital at scale. Getting the meeting requires the right introduction. Keeping the relationship requires delivering outcomes that justify the trust. What the law looks like from here is unrecognizable to the version of it that exists in the legal aid waiting room. Not because it is corrupt, because it is resourced in a way that changes everything about how it functions. Deadlines are met before they are due. Documents are correct before they are reviewed. Problems are identified before they become problems. The system was built with the same rules for everyone. The people applying those rules are not distributed evenly. Level 8. You help write the rules. At the highest levels of wealth, the relationship with the law changes category entirely. Your legal team does not just navigate the regulatory environment, they help shape it. Former partners from your firms sit on advisory committees. The attorneys who represent your interests in Washington are not litigators. They are policy architects, people who understand how legislation is written because they have written it, and who understand how regulation is interpreted because they were in the room where the interpretation was decided. This is not corruption in any simple sense. It is the end point of a system that has always rewarded the concentration of resources. The law, at this level, is not something external that governs your behavior. It is something your people participate in building, refining, and in some cases, designing around your interests before the public has any reason to look at it. The attorneys in this world do not have offices above tax preparation services. They have named floors in glass towers. They have former secretaries of state as senior partners. They have relationships with the people making decisions that most citizens will never be in the same room as. Somewhere in a legal aid clinic, a law student is reviewing a tenant's eviction case on a laptop with 17 other tabs open. The legal system is the same system. The resources inside it are not. You still need a lawyer. What happens next has almost nothing to do with the law. It never did.